This is a case called Imam and Croydon, and we act for the Intervenors Crisis, the homelessness charity, and it's coming up in the Supreme Court in the next few days. In order to understand what the case is about, you need to have a little bit of a background about how homelessness law works in England. So if you're homeless in England and you apply to a local authority for assistance, there are a series of tests they'll apply. Are you actually homeless? What's the reason you became homeless? Have you got a priority need, etc., etc., etc. And if you end up effectively passing all of those tests, you get owed what's called the Section 193 subsection 2 duty, or the main duty. And that's the duty to be rehoused in permanent accommodation by the local authority. In reality, that's the duty most people who apply as homeless want to try and have activated. Now, because of the housing shortage in this country, it's not that easy for local authorities to find you somewhere when you're owed the 1932 duty straight away, because they have to find you accommodation that's suitable. So if you've got a big family, you'll need a bigger house. If you've got a disability, you'll need an adapted house, or whatever the case may be. So what frequently happens, and is what's happening in this case, is the local authority finds you somewhere that's suitable for the time being, but not suitable for you to live in for the rest of your life. So it's not brilliant, but you can put up with it for a bit. Now, what's happened in this case is that the local authority have accepted the accommodation they've provided to the homeless person is not suitable. So they owe her the full 1932 duty, but what they've given her isn't presently suitable. And the question is, what can she do about it? The High Court and the Court of Appeal didn't see crisis involved at all. They were fairly traditional arguments about how homelessness law works, about scope of injunctions, etc. But the local authority have appealed to the Supreme Court, and one of the things they're saying is that in circumstances where they've provided accommodation which is not suitable, the High Court, when deciding what remedy to grant that person, has to take into account the resources available to the local authority, and in essence, if they haven't got enough money to find somewhere, or to build somewhere, or to buy somewhere, that's a relevant factor that could justify not granting any relief and leaving the homeless person in the unsuitable accommodation for a longer period of time. Now, Crisis, we'll come and talk about their intervention in a moment, but Crisis are involved at the Supreme Court level and we're acting for Crisis. You'll immediately understand why Crisis have an interest in this, because there are tens of thousands of people who live in temporary accommodation of varying qualities throughout England. And if it's possible for local authorities to leave them in there for quite long, possibly open-ended periods of time, whilst they wait for their own financial circumstances, the authorities' financial circumstances, to change, that's something that Crisis has a lot to say about.
Crisis wanted to make sure that the Supreme Court had a comprehensive understanding of the ramifications of its decision for the many people that live in temporary accommodation, many of whom are Crisis's own clients. So Crisis wanted to put in evidence about the scale of temporary accommodation and point to the fact that over 100,000 people, both families and children, living in England and Wales now live in temporary accommodation. The funding of temporary accommodation, Crisis put in evidence about the procurement practices of authorities and pointed to the extent to which authorities themselves contribute to the crisis in the temporary accommodation market. And probably most importantly, the quality of temporary accommodation and the effect of living in temporary accommodation on residents. So Crisis drew on the experiences of its own clients to point to the effects of living in temporary accommodation on health, on education, on life opportunities more generally. In terms of submissions, Crisis really wanted to make 2 points about temporary accommodation in intervening. Firstly, Crisis wanted to make the point and take the Supreme Court through the way in which homelessness legislation has been designed and operates. So Crisis made submissions about the discretion that Parliament has deliberately, carefully afforded local authorities under the Housing Act. And it made the point that Parliament has allocated a definite but quite finite amount of discretion to local authorities. And if the authorities' submissions in this case were accepted, that very definite and finite amount of discretion would be modified. And it would be modified in a way that Parliament never intended. Crisis also wanted to make the submission about the consequences of the appeal if the appeal were allowed. And Crisis made the point that if Croydon's submissions were accepted, what it would allow is a family living in temporary accommodation to stay in that accommodation, even if it would allow that family to live in unacceptable or unsuitable temporary accommodation for an indefinite period of time.
Just to place this case in some wider context, I now want to explain what an intervenor is and how the role of an intervenor differs from the main parties in a case. Turning first to the question of what an intervenor is. An intervenor is a third party who applies to the court for permission to intervene in a case. Usually they are public bodies or NGOs, charities such as Crisis, that have a wider interest in the case beyond the initial issues between the parties. An intervenor is not there to argue for or against the appeal necessarily. An intervenor is there to offer a third-party perspective. So how does acting for an intervenor and the role of an intervenor differ from one of the main parties? Firstly, when acting for an intervenor, it's very important to consider what value that intervenor is going to be able to add to the case in order to assist the court. A court is not going to be interested in simply hearing another party rehearse the submissions already made by one of the main parties or to repeat any points. So one has to consider what fresh perspective the intervenor is going to be able to offer. Here, Crisis was able to add value and offer a unique perspective as one of the leading homelessness charities in the UK. Crisis was able to draw upon its casework done on a day-to-day basis in order to create case studies to illustrate to the court, in this case, how the issues that the court is deciding might impact upon a much wider range of people than just the individual concerned in this case. Another key issue for intervenors to consider when intervening in a case such as this is the need for proactivity and to be aware of timings. That's because, as is set out in Practice Direction 6, there's a 10-week time limit for making applications to intervene, in that you should make your application at least 10 weeks before the date of the hearing. Given that intervenors are perhaps often not made aware of hearing dates until a late stage, there can often be a real need to act quickly, and that's why it's so important to instruct counsel at an early stage if possible. Another key issue for intervenors is the need for proactivity and cooperation with other parties. That's important both on a procedural level because the practice direction requires you, when you submit your application, to say whether the other parties consent, and if not, to set out the reasons why they don't consent. But also it's helpful in making the intervention because it will enable you to highlight gaps in the other parties' cases in order to ensure that, and that's going back to my first point, ensure that value is being added and that you are assisting the court with your intervention. Another unique issue facing intervenors is the need for conciseness, and that's because intervenors are often limited to just 20 pages or 15 pages of submissions and perhaps half an hour of oral submissions. It's a classic case of I didn't have time to write you a short letter, so I wrote you a long letter. Intervenors quite often have to spend considerable amounts of time preparing their cases because it is so difficult to put your case in a clear and complete way whilst complying with those fairly strict time and page limits.
So this isn't just about housing and about people in temporary accommodation. That's the immediate subject of the appeal. But the issue involved here, and the reason it's in the Supreme Court, goes far beyond that. The broader issue is how, in times of local authority austerity, how do you grapple with finite budgets against significant need? And if the Supreme Court accepts the submissions of the appellant, you're likely to see this kind of argument coming up in all kinds of situations, from schooling provision, community care, traveller site provision, whatever the case may be. Wherever there's something to be provided that's very expensive, the argument will be, I can't do it yet, I simply don't have the money in the budget. One of the things the court's going to have to grapple with is to what extent is that a legal as opposed to a political question. But that's why the input of an intervenor is so important. It's about trying to bring home to the court how this decision will impact beyond the immediate facts and even beyond the immediate statutory scheme.
Barristers from Landmark Chamber's public interest team frequently act in interventions such as this, and for example in the past have acted for organisations such as Friends of the Earth, Safer Renting and Freedom from Torture.